offices here. The moderator has already introduced the 5 speakers, and I'll just very briefly introduce a little bit what we are going to do this morning. So we will first have a presentation of every speaker in the order which they are in the program, which is also the alphabetical order of the different patent systems, of the different patent offices. And then I'll ask them each one question just to break up the flow a little bit. After that, we will have a round of discussion, basically first on the question on what are some of the big challenges patent offices are currently faced with. And then if we have time, we will try to do another round where we will ask a little bit about the role of patent offices in terms of particularly dealing with big global challenges like health, the environment, and then a couple of other issues. If we have time, we will try to open up the floor a little bit for some discussion with the floor as well. So with that, I'll pass to the first speaker, who is Raymond Lutz. He's Vice President at the European Patent Office, to give his presentation. Mr. Lutz.
We are waiting for the slides. Good morning, ladies and gentlemen. It's a great pleasure for me to participating at this big conference, and I would like to thank the organizers, the Japan Patent Office and the OECD for inviting the EPO. With my short presentation, firstly, I would like to give you some background on the European Patent Organization and the EPO, the European Patent Office. Furthermore, I want to explain what we see to be the big challenges in the patent world today and how the EPO is trying to meet these challenges. Next slide. Next slide. No, it works. Thank you. The European Patent Organization was created in 1973, and the European Patent Office is the executive arm of our organization and is the patent office for Europe. Our organization consists of 38 member states, including all 28 EU member states. Our 7,000 employees have 35 different nationalities, and among these 7,000 employees, we have 4,100 highly specialized engineers and scientists. These are our patent examiners. We are fully self-financed by our fees and manage a budget of about 2 billion euro per year. Patents granted by the European Patent Office can be validated in up to 40 European states, 38 member states, plus 2 extension states. One new element you see at the end that there is indicated that we are preparing validation agreements with a number of neighboring countries to Europe, and the first one with Morocco will enter into force in the first half of 2015. So then in 48 states, European patents may be validated. This one I will skip. We were asked to shorten a bit our presentations. To some extent, the patent system has become a victim of its own success. The volumes of applications globally are rising very rapidly, especially in Asia. Last year, 2.2 million patent applications were filed only with the IP5 offices. At the same time, the fraction of applications which contain particularly complex subject matter demanding highly skilled patent examiners is increasing. This is particularly true in the fields of information technology and biotechnology. Another significant factor is the growing awareness of the importance of IP in society and indeed criticism of the role and value of patents in certain technical fields. Not only quality and efficiency will address this criticism, transparency is also required, a topic to which the European Patent Office attached great importance. The EPO is facing the challenges of today's IP environment head-on. The primary approaches are a continuous focus on quality, despite the strain of an increased workload. Quality and therefore legal certainty is crucial to the holders of patents and for the credibility of the system as a whole. At the same time, the EPO aims to drive up efficiency by, for example, improving formal processes and, importantly, in a globalized system by enhancing the exchange of data between offices. The EPO is also looking with patent offices around the world at harmonizing aspects of the patent system. We are continuously improving its services to users of the system with these priorities in mind. Let me present some of these services to you. ESPASnet is our online free-of-charge patent information service. ESPASnet provides comprehensive access to over 80 million patent documents and is most important for patent transparency. Not only can users of this system search for documents, ESPASnet also provides information about patent families, legal status data, and citations of other patent documents or citing documents. In addition, ESPASnet provides links to the European Patent Register, allowing the documents relating to applications before the EPO to be retrieved. ESPASnet has now been enhanced by the EPO's Global Dossier. This tool is a collaboration between the world's 5 largest patent offices, the IP5 offices. It gives users direct on-demand access to file wrapper documents since June this year from both the EPO's and SIPO's register. It is expected that within the first half of 2015, the EPO's Global Dossier will provide live access to the registers of all IP5 offices. A further tool which enhances transparency and accessibility to patent information is the EPO's Patent Translate service. This tool provides, in ESPASnet also, a translation of patent documents from 32 languages, including Chinese, Japanese, Korean, and Russian, into English. The tool is a proved success. Currently, 15,000 to 20,000 translation requests are processed each day. This I will skip. Another tool which makes patent documents better searchable is patent classification. Since 1st January 2013, the joint EPO-USPTO cooperative patent classification, the so-called CPC, has been in force. By adopting the same highly granular classification scheme, search for patents has become easier for patent examiners and users of the system alike. Furthermore, the CPC scheme has now been adopted by SIPO, CAIPO, Rospatent, INPI Brazil, and some other offices. The EPO considers the wide adoption of the CPC already in such a short time to be a large step forward in technical harmonization of the patent system to the benefit of patent offices and the wider user community. I will skip this and this also. Allow me, at the end of my short presentation, a few words on European harmonization project, the unitary patent protection, and the unitary patent court. The advantages of the unitary patent protection are a unitary effect over all 25 participating EU member states and a simplified post-grant patent administration at the EPO, which will lead to simplification for patent holders, leading to savings in administrative and translation costs. The Unified Patent Court, on the other hand, provides a single body for patent litigation in Europe. This patent court offers both a harmonization of case law and enhanced legal certainty. The new unitary patent will, once launched, provide an additional option next to the well-known classical European patent, which will also exist in future. It is expected that this new system, unitary patent and unitary patent court, will enter into force in 2016. This brings me to the end of my short presentation. I would like to thank you very much for your attention. Thank you.
That a little bit already, but could you perhaps say a little bit more about the benefits you see flowing from that for European system?
Well, the situation in Europe today is that the European Patent Office grants a patent, and then the patent holder has to decide where this patent should be validated. And the patent holder has then to go to each and every national patent office to validate this patent. In future, with the unitary patent, you can go directly to the European Patent Office, and in one go, with no additional translations, you can validate this granted patent in a block of 25 European states, all EU member states. This is a huge simplification and a huge reduction of administrative costs and also administrative work. This will be of great benefit for all of our users.
Thank you very much. We will move to the second presentation in the panel by Mr. Yoshitake Kihara. Mr. Yoshitake Kihara, who's the Deputy Commissioner of JPO and our host here in Tokyo. Mr. Kihara, please.
Thank you very much, Mr. Pilat, and good morning to you all. My name is Kihara, Deputy Commissioner of JPO. I'm waiting for my PowerPoint slide. At the beginning, I'd like to extend my great appreciation to Dr. Pilat from OECD and all the high-ranking members of the IP5. It is a great pleasure for me to be able to be one of the panelists here to talk about IP system in Japan to promote innovation, and particularly I focus on the patents, and I also introduce to you Japanese government IP policy. In 2002, the Koizumi cabinet declared that Japan will pride itself on the utilization and promotion of the IPs. And since then, our priority is speedier and more efficient the examination of patents, and what we call FA period has been reduced to 11 months by the end of fiscal 2013. In fact, this is our original target, and we needed to increase the examiners. But because of the budget constraints, we increased the number of the fixed-term examiners, and the total number of examiners has been at 1,700. And also, instead of examiners doing everything in order to reduce the burden and the backlog, we have decided to use the outside organizations or registered the research organizations for preliminary research of the prior art. And also the FA period reached the 30 months at one time, but at the end of fiscal 2013, that is the March of this year, we have achieved our target of FA pendency to the 11 months, and the number of FA pendency has been reduced to the 910,000 to 191,000. And so, as I said, the Japanese government has been promoting the importance of the IPs, and the growth strategy of the Abe government, which is the one of the three the arrows of the economic policy of the current administration. The IP strategy has been one of the most important parts. And we have been working to shorten the examination period as much as possible so that we can be the fastest the examining organizations. We have been focusing upon the FA, but at the same time, the period until the protection also have to be reduced for the users. And we have been working to reduce the standardized the period until the rights registration to 14 months. And of course, the timing is very important for businesses for their the appropriate implementation of their business strategies. So the timely examination is another focus for us. And we have introduced what we call the collective examination system. This is an example of the electric vehicle. So this organization, the business, needs the invention of batteries and motors in order to launch electric vehicle as much as possible into the market. And design of the car must be protected, and also the logo of this the vehicle will also be protected. So the portfolio of the rights concerning this electric vehicle will be applied for examination and protection, and the group of examiners are collected as a team who meet the business representatives from this company at a meeting, and for the expedited and the simultaneous the application examination. And that way, this business can benefit from having a portfolio of their IP rights. And the businesses have been welcoming this, and we are very pleased to work closely with the businesses. And also the different applications, and also the applications which have already been applied, will also be eligible for the collective examination since the October this year. And also we also raised the quality of examination to the highest degrees. This is what we call the PDCA cycle, on which we have been working. In April this year, we have formulated the quality policy on patent examination, and this also applies for the design and the utility models. with this, we'd like to meet the wide-ranging needs and expectations of the industry. So examiners work with these principles in mind day by day. At the same time, we have established a committee of external experts so that they advise us as to how we have been improving the quality of examination. And this committee was formed in August this year. And also in our everyday activities, as you can see at the bottom of this slide, we need to understand the current status of quality. And we conducted the questionnaire surveys of our users as well. And 93% responded that we have been working a lot better and higher than they expected in general. But when it comes to the specific items, well, in Japan, the search has been good, but the search for overseas market or the foreign language literatures, that quality is yet to be improved according to the user survey. So this is a kind of the quality audit of our examiners. And our experienced examiners has been designated as the auditor of their colleagues for quality improvement. And also the group of examiners discuss together to make a collective decision in order not to have the uneven quality of the examination. And instead of simply focusing upon, as I said, that we have the commission our search, not only domestic literature, but also foreign language literature to registered the search organizations. That is the outsourcing of our preliminary search to outside organizations. And Chinese and Korean language literature represent quite a large volume, but language can be the barrier. So we have developed the machine translation system. And on Thursday last year, the pilot version of this system has been launched. And not only our staff members, but also outsiders can access, and the literature they published after 2003 can be translated if they are published in Chinese and Korean. And the highway members have been increased to 33. We'd like to increase this number further, membership further, so that the IP authorities will be able to benefit to expedite their workload. This has been introduced since 2006. And also in April this year, part of the patent law was amended in Japan. And so the relief measures have been introduced, and also the simultaneous filing has been is now possible under the Design Act, and under the Trademark Act. The sound and the colors are now being registered, and also the regional collective trademarks are possible for expanded the entities. And the patent attorney's law was revised, and also the simplified procedure for the payment system, fee payment system has been introduced. And Japan revitalization strategy states that the incentives should be provided to promote employee invention system, as well as the ensuring the innovation and the competitiveness of the businesses. And this has been discussed by the Patent System Subcommittee of the Council of Industrial Structure of the government. Thank you very much.
Thank you very much, Mr. Kihara, for also a very interesting presentation on JPO's activities. I think we are already seeing with two presentations a number of common themes in terms of quality, efficiency, speed, sort of also dealing with more and more translations as some of the issues which I think are very interesting. I had one question to you, perhaps on the issue of the approach which you mentioned on what's called collective examination. It seems to be something which I hadn't seen before. Could you elaborate a little bit further on that? I mean, you spoke about it a little bit already, but if you can say a little bit more about why you're doing it and what exactly you're trying to achieve with that.
Yes, thank you very much for your question. In 2010, we started this collective examination system, but prior to that, actually related applications should be examined at the same time. We recognize such a needs previously. Before, we consulted many businesses, and of course, the individual, the patent protection is important for businesses, but at the same time, they need the right timing for the launch of their new products by having the portfolio of rights relevant to a certain product. And that's why we started this formally 2 years ago.
안녕하십니까. 한국특허청 차장 이준석입니다.
Good morning, ladies and gentlemen. I'm so happy to see you all. First of all, OECD IP statistics for decision makers. I'd like to say thank you so much for giving me the opportunity to talk to you, to the audience. And I hope that through this discussion, we can contribute to the development of the IP5 related activities, and also we can exchange the information about the IP5 recent development. First of all, I would like to talk about the statistics of the Korean situation, and after that I will be Korean situation. And after that, I will be touch upon the Korean authorities' policies. As you can see, this is a recent trend of the IP statistics in Korea. 2014 August is the latest information. The growth rate is 9% in patent and 3% for the trademarks. Meanwhile, design and utility models became negative, minus 12.1 and minus 5.2, so in total 4% increase. So as you see on the screen, that the patents and trademarks are increasing in numbers. In case of a patent, domestic universities and institutions and the research laboratories are increasing in numbers the last 10 years. Then what about the PCT applications? The KIPO is the reception institution for this PCT application, and as of August this year, 8,112 PCT applications were accepted by KIPO. And this is 3% growth against the previous year. However, the growth rate itself has decelerated a little bit. Next is about the government of Korea's new growth paradigm policies and also recent IP policies. Last year, February, new government was born. Under this new administration, the growth engine was set as a target, and the creative economy became a keyword of their policies. And government-wide strategy was also announced. The innovations and then technologies and then IPs are all key factors for the creative economy, and the basic platform there is the intellectual property. So CAIPO last June also came up with the operational policies, special policy for IP-based creative economy promotion policies. Creative idea must be protected by the high-quality IP, so that promoting the use of the IP, at the same time protecting it, we can enhance the ecosystem of the IP of Korea. KIPO is currently working on establishing a high-quality platform, and we changed the we reviewed the examination bureaus and introduced the simultaneous examinations, and also to have the accelerated examination policies. Last year 13.5, and then this year is the 11.5 months that we are aiming at by the end of this year. As for the average first action pendency, 2015, 10 months. And as for the trademarks, 5 months are our target, so that we are currently increasing the human resources, increasing the budget, so that enhancing the capability of examinations. The CAIPO, the last year, September, we created a new organization. It transformed from the old economy-based organization to the new economy or creativity economy oriented type of the organizations. And a new bureau was established to work on this, the new creative economies. We also divided this organization into 3 different bureaus according to the units of the art, so that we can increase the capability and then deepening the understanding of that particular industry. So we have close connectivity and partnership with the industries and also the bureaus, so that we can provide high-quality examination activities, and this is a platform for that. Next one is about the positive examination services and also collective examination system that we introduced recently. This year, January, we started positive examination service. This is to help the applicants to show the proper scope of inventions, and we enhance the communication between the applicant and the authority so that we can create a high-quality patent. As for collective examination system, as Mr. Kihara said, as for one product, we can examine multiple applications simultaneously, so that we can grant the patent for several applications at the same time. Patent and utilities, we granted this collective examination system, and we included also other items this year. So not just the patent, but also utilities and trademarks and then design. You can get these result of the examination at the same time. We have high hope that it will be contributing to the commercialization of the IP. Next, I'd like to talk about what are the promotion policy for the IP utilization and commercialization. When we talk to SMEs, the commercialization of the IP has been a very difficult challenge for them. They don't have enough human resources, they don't have enough marketing capabilities, and furthermore, the biggest challenge for them is a fund. Therefore, that the CAIPO is providing the funds for them to commercialize the IPs when the IP is in high quality range. Since last year, the KDB, with the cooperation of the Korea Development Bank, those companies which do not have enough funds can make a loan out of a bank based on IP. This year, the Industrial Bank of Korea and Uri Bank, we have expanded the pool of banks which can provide the loan based on IPs. For the commercialization of the IP, the fundings are necessary. And first of all, you need to have a good assessment of the IP. And we also support the budget to do the fair IP valuations. January this year, we created a special institution called Korea Institute of Intellectual Property Evaluation and Transaction, which is called KIPET in abbreviation. Next, information use and also promotion of the proliferation of these information. The publishing and also sharing of the information are very important, and then we call it Government 3.0 policies. The government-owned information should be publicized to the audience and general public so that the private sector can make use of the information. That's conducive to the new innovations on the market. The overseas data are also collected by the KIPO and expanding its database. Lastly, let me talk a little bit about the recent development about the patents and utility models. First of all, we are enhancing, protecting the rights of the applicants so that they can submit the papers as it is, and also even the application paper can be submitted, even they submitted overseas. And this amendment of the Utility Model Act and Patent Act will be go into effect next year. You can use the same paper which submitted overseas to the authority in Korea, and also amended the examination standard by assimilating examination guidelines for separate technological field. And also the computer programming related contents are also included. As for Trademark Act, we provide measures to stop the unjust registration and exercise of a trademark rights. We try to stop the violation of the principle of good faith and cracking down on trademark brokers. As for the design, the government of Korea ascended the Hague system, and Japan is currently preparing for joining the Hague system. I hope that they will join soon so that we can collaborate each other even for the Hague system. That's it for the summary of the Korean situation.
Thank you, Mr. Lee, also for a very interesting presentation. And I think we came across a number of the same issues again, but I think you're the first of the speakers who've also talked a little bit about trademarks, because this is the first conference which we're doing where we're also trying to go a little bit beyond patents. So I was wondering whether you can say a little bit more about trademarks and what you see as some of the challenges in that area. You already mentioned that you're changing the Trademark Act, but if there are any other things you would like to signal there, would be very helpful.
Yes, at KIPO, in case of a Trademark Act, as you know, the mechanism is a bit different from the patent. Trademark Act is to stimulate the competition among the stakeholders. So unjust registration of a trademark so that they just prevent others to get that same trademark. This type of trademark squatters should be avoided. And one time, there was a very big attention given to this type of squatters. But a trademark act should not prevent the competition. And also, as for the SME activities, the trademark should not limit the activities of the small companies. Trademark squatters sometimes get all the trademarks and prevent or sometimes asks the small companies to pay the license fee for them. So for this type of acts, even before getting the trademark, when the small company started using the trademark before that squatter got the trademarks, then we changed the act so that we can protect those small companies. They can continue using the trademark. We always try to make the policy.
Stay away from the office statistics and that sort of thing. Other than to say that one really excellent development at our office is that we are now in a stable funding model, rather. For many, many, many years, ever since I've been here, almost 30 now, we've had issues with our funding. Although we collect our user fees, it has been required that the Congress reappropriate them back to us, which they have not always done in full. And that has caused many, many, many problems. The American Invents Act, however, seems to have rectified that. We now statutorily keep our fees, and also we have the ability to build up a reserve fund, which we are doing. This has enabled us to do a couple of very important things. One is actually stay on target to remove our backlog problem, which is something I never thought that I would see as long as I was there. Secondly, enables us to get back on the IT track, right? So when funding was cut, the first thing that was cut in the office was the IT improvements, because we wanted to keep the examination flowing in order to keep the revenue coming in, no matter what happened to it, and so on. So we're finally going to be able to get back on track with our IT improvements. But probably the most significant thing that we are going to be able to do, and are in the process of beginning, is make significant investments in quality. I use a phrase, bringing scholarship back to the job for the examiners, much more intensive training, much more tools. We're paying for law school again. We're paying for after-hours technical education, for example, if an examiner wants to get a master's degree. We're bringing more corporations in to train our examiners, and on and on and on. And we're currently in a process of outreach to the public to find the best ideas and the best practices with them. Let's see. Okay, so I wanted to just maybe talk a little bit more economically. Okay, so many of you may already know this, but in the United States, there's been a long-standing industrial policy to get the little guy into the office at the lowest possible cost. It's a tradition in the United States. And we have done that through fee reductions. Mainly, we always provide help for pro se applicants. For example, we advocate that this be a global practice. It is not. However, in the United States, it does apply to all filers, not just Americans, but anyone. This helps. Ideally, there would be some private sector help for the small guy. I'm talking in terms of attorney's fees. That is a private sector issue. It would be ideal if there were some provision for the small guy, more in an economic sense there. All right. So why is this really important? It's important, and actually, I'm going to cite a study. I can't remember the author. The author is perhaps in this room, who noted that in the United States, of firms that receive patents, small business, in terms of patents per employee, exceed those of large corporation by 15 times. 15 times more patents per employee for small business over the large firms, right? That's significant, right? And also in the United States, you know, we all view in the United States that the engine of job creation is small business, right? The small business that innovate, they're the ones that create new jobs. Thanks. Okay, and in further trying to foster that tradition of looking out for the little guys, I say, the American Invents Act, which thankfully helped us with our funding, also look to help further the smaller segment of our inventor community. For micro entities, which are the smallest of small inventors, a full 75% reduction in all fees. It also establishes a pro bono program where the office is working with various bar associations in all of the states, frankly, to add patent services to the pro bono portfolio that exists today. The AIA also creates lower cost administrative trials as a lower cost way to avoid, you know, very expensive litigation. Also recently, the office established was known as the Office of Innovation Development. For many, many years, we had an independent inventor outreach program, you know, very, very limited. What we've done here is greatly expanded that, right? And it's really not just independent inventors, but all in under-resourced and underrepresented groups. So this operations here have ties to the Small Business Administration, to the Minority Business Development Agency, and there's a long list of innovation and inventor community groups in each of the 50 states that they work with. So outreach is a big part of that for them. A second key aspect of the U.S. IP system is the scope of protection, right? Software, we have always tried to take the most expansive possible view of that, which is, you know, indeed why we have a software industry, think Silicon Valley. The same with pharma and biotech. The United States perhaps has the most advanced pharma and biotech industries on account of the IP protection there. I'm going to come back to that in just a moment. And also, U.S. patent rights are very valuable because they're enforced. And speaking of litigation, we've had a very, very significant decline in litigation lately. This is perhaps part in view of the fact that we are now engaged in these administrative trials at the office, which were enacted by the ANA, and those are having an effect. But also, we've had some interesting Supreme Court case law emerge over the last several months, which may be having an effect on that as well. And in reference to both bullets, the case I'm referring to is one called Alice versus CLS Bank, which was relating to business method patents, right? The Supreme Court held that this particular patent was invalid or ineligible for patent protection because of the subject matter is not anything more than an abstract idea, and I'm going to have to quote the court there. Now, one thing that you as economists should be really interested in following is what is the effect of that case, right? Not only on the scope of patent protection and the numbers of patents that are applied for in the software areas, particularly the business method area, but for those patents that currently exist, to what level are those patent owners not pursuing people in litigation, fearing that those patents might be invalidated for ineligibility? So significant changes in the law. And I will just close by saying that I'm a relative newcomer to reading some of the literature that you produce, you know, individually and collectively. It's fascinating. Yes, it's needed for policy development, as I said earlier, but I also want to add that those of us that are trying to help run large patent offices, knowing what the trends are, why things are happening, why filings are up in a certain technical sector or why they're down, are things that really can help us manage our offices. So I will stop with that, Dirk. Thank you.
Thank you very much.